This is Kathy Vaughan for CN Live. We have on the line Deepa Govindarajan Driver, Dr. Deepa, who was in supposedly the last case management hearing for Julian Assange on Friday, the 14th of August. We were on the press line, but things certainly didn't go as planned. It seemed like a bit of a mess. So, Deepa, you were in the courtroom on the day, so you would have seen and heard a lot more than what we would have. So could you please enlighten us as to what went on?
Sure. I'll tell you a little bit about how difficult it is to get into the court, because we talk about open justice here in the UK, and there were colleagues who came all the way from France and other parts of the world, and they queued from about 6 a.m. to be able to enter the court at 9. We were queuing outside, and then when we got in, we again queued outside the courtroom. We then found that Miss Iverson, who was representing Mr. Assange, came to the court official who was outside the door and said they had not yet been able to make contact with Mr. Assange in Belmarsh.
What time was this?
This was at about just before 10 o'clock, and the hearing was supposed to start at 10. So it was very interesting that even Julian's lawyers are not able to make contact with him, even on a day when he's supposedly in the interview room. And as you know, they haven't had any proper contact with him since February. So I believe they wanted to take instructions, given the second superseding indictment, that is the third indictment in effect, had now been presented. What's really interesting is Julian has not yet been arrested under that new indictment. So I don't know the law of this, but it looks like he's in limbo. So he's in Belmarsh, not serving time for any crime that he has committed. He is on remand for over a year, having had a chronic lung condition since 2012, and he was coughing in court, and he didn't seem to have PPE, and I understand the guards at Belmarsh don't have PPE either. So the lawyer comes out and she says to the official they can't find him. The official then goes away, tries to find him. So we're standing there, and it's still almost 11:15 when we finally make it into court. When we made it into court, what was really funny was that there was no prosecutor there. So all of a sudden, they appeared to realize that the prosecution team were not aware there was a hearing that morning. And confusion appeared to arise because the court lists listed the case at 3:30 p.m. when actually Vanessa Beretta, the judge at the previous hearing, had said that the case was going to be held at 10 a.m. So then they spent a little bit of time trying to find the prosecutor, which was another joke. They said, it'll take her half an hour to drive in, or you can try and connect her on a line. They tried to connect her on a line. And when
we're talking about Claire Dubin, are we?
That's right, yeah. And when they managed to connect her, to the wrong court. And then Gareth Pearce, who's Julian's lead counsel, and Mr. Smith, who's appearing for the prosecution, both passed on messages that they had been cut off. So there was a real mess happening. And of course, the journalists were on the line, and we were aware that journalists were unable to hear what was going on in court. In addition to this, what is really, really important that doesn't come through in the reports is that while we were queuing outside the court, remember, these are people who have been queuing from either 6 a.m. or 7 a.m. in the morning. And we were told after queuing outside the court door that there would be no public allowed. So initially we were told 6 members of the public would be allowed in court. This is a court where there is no transcription, no audio recording. And you know how poorly Julian's case has been covered by the mainstream media. So we were then told no members of the public would be allowed. And then there was a big argument about this, because obviously we had previously been told 6 would be allowed, and all of a sudden they seemed to have changed their mind. John Shipton, Julian's father, and Stella, Julian's partner, were both there. And many of the people standing outside felt very agitated because they weren't even going to allow them in. So we insisted that they should be allowed in first. And then as a result, in the public gallery, we only had 4 spaces for the public. So people who had queued from very, very early in the morning didn't get in. So finally we were inside, and they managed to find Claire Dubin. They managed to, after a long time, connect both the defense and the prosecution. For the defense, Florence Iverson was representing in court, and she was on time, obviously. And by now it was about 11 o'clock, and they still were dithering. Julian, all this while, had been sitting in this video interview room, which is a shared space, and being exposed, therefore, to COVID, potentially, because there are so many people who come in and out of those rooms. Vanessa Baraitser then was annoyed by the noise in the prison that you could hear from the prison. So you can imagine what a tormenting situation this is for somebody like Julian, because he's been brought in, he's sitting down for an hour waiting. He doesn't know when the proceedings will start, what they will be about, because he hasn't had a chance to talk to his lawyers. And he's presumably always under the stress that he might get exposed to COVID or whatever other infections there are. At about 11:15, the proceedings finally started. The prosecutor explained how in the American system of superseding indictments is such that, according to their expert, Mr. Cromwell, the fundamental basis upon which the extradition was requested had not changed despite the new indictment. The new indictment sets out the conduct of Mr. Assange and expands how Julian's alleged conduct shows a pattern of conduct. And the idea is that Julian conspired with hackers. Julian's lawyers said that they felt that a lot of what the prosecution was alleging, for example, in paragraphs 19, 20, and 22 of the superseding indictment, was related to material available since 2010 and 2011, and there is nothing new in it. And therefore, all this superseding indictment adds is narrative. And where it adds this narrative could have been provided earlier, and therefore they are asking the court to exclude this from the proceedings, because obviously not only have they missed the timeline once, as in provided the first superseding indictment, they've now missed the timeline twice and abused it and brought back a second superseding indictment. What is also interesting is that in doing so, they have not tried to say that Julian's done anything different. They've just added more information. And their argument is that in the US, it is common for prosecutors to continue investigating the accused even after they have been arrested. And therefore, this is common practice in the US, and therefore the British court should accept it.
Well, so what? None of this is new at all. It just seems like a ploy to stall until after the elections. Would you agree?
Well, it's really interesting because it sounds to me more like what Stratfor was saying, which was they were going to keep Julian in limbo for 25 years, move him from country to country, keep him in absolute misery, break him down, destroy his mental health, destroy his family and friends.
Until he made a nice bride in prison.
Yeah. And remember them even referring to making him eat cat food in prison. That was so they are really tormenting him. And it was, for me, very distressing to see John Shipton and Stella in the room, because I don't know Stella at all. So I had seen her for the first time in person. And I was very saddened by how it must be for a partner to watch this kind of torment. And she clearly has a great deal of affection and love for Julian. So it must be incredibly hard, especially with two young children.
Stella has been in the courtroom before. Mm-hmm. Are you saying this time she was in the public gallery?
Yes.
So you don't have any idea why she couldn't go into the courtroom this time?
I'm sorry, this is not a question I can answer, actually. The other interesting things out of it is Vanessa Baraitser, as usual, the judge, she wanted to know if Iverson was suggesting that the request from the US had been brought in bad faith, whether it was an abusive process, and as a result, whether the defense wished to vacate the hearing in September. And as you can imagine, this was quite an interesting question coming from a judge who has gone personally out of her way to make sure there is a courtroom available in September for the hearing, and has pressured the defense a lot to ensure they stick to the strict timelines that she suggested. Yeah. So it was very interesting to hear her ask.
She has also given her reasons when they wanted to put things off because of the pandemic and lockdowns, etc. She did say there is a prisoner here who needs to be processed as quickly as possible, implying that he had the right to a speedy trial or speedy process.
I have notes from a hearing where she specifically said, and in court she said this, so I'm not implying anything from her words. She specifically said in court to the prosecutor, but the government wanted to process this case quickly. She is clearly mindful of what the government's timeline and agenda are. And
which government?
While the British government, I would assume.
Right.
That is a question, but not one I'm intending to bring up here. We then had yet another interruption at about 11:30 where Gareth Pearce and Mr. Smith were no longer on the line. They had communications difficulties. Iverson said she'd reply by Friday and then Beretta said she wouldn't be there on Friday. And then they said, okay, by Wednesday, if you want to move the hearing out of September.
I understood that meant postpone.
That's right. So postpone to another date.
Because they were going to need more time because it was obvious that the new indictment was going to be accepted, even though it was so late.
Well, it is interesting. The other thing that's quite interesting is that the prosecution is now going to submit psychiatric evidence on the 24th of August, when the date for the skeleton argument that the defense has to submit is the 25th of August. So the defense asked, could the prosecution submit this information slightly earlier because they have less than 1 day to respond. Yeah. And Vanessa Perez has still made the ruling. They would have to come back on the 25th.
Right.
As far as I'm concerned, the substance of the hearing was, is there anything new in the second superseding indictment that is different from what was there before? There are no new charges. Given there are no new charges, could this information have been provided beforehand? Yes, of course it could. But the Americans still feel that they're allowed to provide this information. Beretta has to make a ruling. She will make a ruling in due course, but she will make it during the hearing. Now, this puts, of course, Julian's team to a disadvantage because they will have to do all this work potentially in relation to whether the second superseding indictment will be allowed or not, or the commentary within it. And yet that might or might not be used, which means that given they have very limited time, this is an absolute travesty again.
Wasting their time.
Wasting their time, wasting the court's time, making things difficult for Julian. And then at the end of all of this, Miss Iverson politely asked if she might be allowed to continue on that same conference line to continue to speak to Mr. Assange in private. And Vanessa Perez said, I'll ask the jailer. And they came back saying, due to lunch breaks, we will not be able to accommodate that because the hearing had overrun by 35 minutes.
It didn't overrun, it was late in starting.
Exactly. In effect, it started by over an hour late.
Didn't Beretta say that it was not within her powers to put the new indictment aside?
They discussed whether there was a need for more legal argument in relation to whether that could be included. Julian's lawyers agreed to provide that legal argument should it be needed by the judge. So I believe that is still in limbo. So to me, it seems like
Can we just
Friday,
clarify, though? Is it going to be decided on the 25th or the Friday?
It's not clear. The judge seemed to suggest that not only will the arrest of Julian, the formal arrest of Julian under the second superseding indictment take place in that first week of the extradition trial, she would opine on it in that week as well. Which I think must be very difficult for Julian's lawyers because it is an absolute nonsense that this is being allowed to be brought in at this time or that the US is doing it at this time. And now, of course, it must be very difficult for them to not only prepare for the hearing, but also prepare for this second superseding indictment and not know whether the materials that they prepare will actually be used or otherwise.
I'm just rather confused about why he needs to be arrested again when he is in prison. If he needs to be arrested, one would think that means technically he's a free man at the moment and just being held.
I did wonder that, and I'm not a legal expert. My conjecture is that if his lawyers were to make an application for him to come free, they would just rearrest him before he was allowed to come free. So it's a charade too, which is part of the formal process rather than anything else. I don't know, and I cannot speak for them.
Yeah, it's a bit mysterious.
Yeah, it's all it's a process that seems to suggest that Britain is a state where the rule of law counts, where open justice counts. You can see that Corona, I mean, a lot of people have been concerned about the erosion of civil liberties and human rights as a result of COVID-related legislation, both here in Australia and in other parts of the world. But in particular, in the UK, it is being used to exclude families of prisoners from seeing them. It's being used to prevent lawyers from seeing their clients. In a case where there are several 100,000 pages of documents that people have to read and take instruction on, it is extremely improper that Julian was not granted bail, firstly, to stay safe during COVID, and secondly, to prepare for his upcoming trial, that he's been given a computer where the keys have been glued down. And this, to me, doesn't speak of the rule of law. This speaks to me of a highly, unashamedly fascist state, which is providing a little veneer of the rule of law, for example, by allowing 4 members of a public in a case of this prominence into the courtroom. And then
no proper line for the rest of the press.
No proper line for the journalists or others too.
Yeah, we were all shut out.
You would have thought that having had several such sessions, by now they would have worked out how they can dial somebody in. But it just seems a complete mess.
Well, the other thing is the absence of any kind of recording or transcript. This seems to have become a standard.
Often Julian's court is listed for the courtrooms that have the transcription, but ends up in a courtroom which doesn't have transcription.
Right.
One of the things about the transcription is that it is extortionately expensive. Absolutely. They've outsourced it to a private firm, and you have to go through the private firm to get a copy. If this is what open justice is about, then you're denying justice to people, because nobody who is of ordinary means can access the transcription.
Yeah, how much does it cost? Sorry.
I think close to £1,000 for a session like Julian's. But it is an extortionate amount of money. This is also about the privatization and the neoliberal attitude that has permeated Her Majesty's Court and Tribunal services, where people are being denied justice because the court and tribunal service is hugely underfunded. We don't have the kind of pro bono litigation support that we used to have to the same extent. The defendants are in a position where they have no contact with their family or their lawyers, especially during COVID. People's mental health is deteriorating significantly in prisons. And there is not enough care here. Now, whatever you want to accuse Julian of, at least he deserves a fair hearing, a fair trial, an ability to participate in the trial reasonably. Whether it is the physical barriers of a glass box or the financial barriers of the cost of a transcript that prevents justice from being served, these barriers need to be dismantled.
Yeah, that's right. I mean, I even wrote to the court myself as a technical person and explained how they could fix their four technical audio problems. And it seemed when I'd missed out on one or two because the others just drove us mad. The last one I listened to, there was just almost zero intelligible coming down the line. But this time it sounded okay. But then mysteriously, Vanessa Barreto just left the conference and the press were just completely cut off just as it was starting. There is no explanation that I can think of why the judge herself signed out or was signed out just before it was about to start.
I think there is also this question of, firstly, mainstream media weren't interested, but maybe on important dates they might be. And when there are important dates where they might be, It's very interesting that there are always coincidences that prevent them from listening in, which make it very difficult. Kevin Gostola was saying that he dialed in. He's obviously not mainstream media, but he's very critical and very insightful. He dialed in close to 3 a.m. for him. And for over an hour and a half, he was on music. So if you were a mainstream media journalist who has to put in 3 stories a day, and Assange was one of the stories you were covering,
you're going to pass
would
it.
you really stay and listen and wait and hope that you would hear? Obviously not. And then you'd just work on the press release. So the justice that was due from Open Justice, from having journalists and citizens cover what's happening in court and understand what's happening with due process, is being stifled intentionally through these kinds of mistakes.
I think it was Juan Passarelli who summed up his first point was that the court demonstrated masterfully their incompetence. But it's just every time. It's the same every time. And Reporters Without Borders said that they'd been listening in on every single one of them, and they had never learned enough to make a report.
A lot of these plausible mistakes, when they happen, you just wonder whether there is any such thing as a coincidence, or if this is a ploy, because it's so difficult to even figure out how many spaces will be available, which court, what time you need to arrive to be able to get in. All this makes it difficult for people to participate and doesn't allow for citizens to really have a fair scrutiny of this trial.
Oh, definitely not. No, it's been very, very frustrating. But thankfully, we've always had some reliable people in the courtroom. Marty Silk, Mohammed Omazi, and yourself, who has been able to talk to us. And thank you so much, Deepa, for coming on the show again.
Thank you, Kathy. I'm always very glad to be able to support CN Live, because you've been doing amazing work reporting not just this case, but many of the other important issues that we're dealing with. So thank you for inviting me, and I'm glad to be able to bear witness to the torture and persecution of Julian Assange rather than the prosecution of Julian Assange. Thank you.